Bulavinaka, I'm Vijay Narayan. This is Fiji Village on record, and from the desk, this breaking news from court. High Court Judge Justice Dane Tuiqereqere has ruled that the Commission of Inquiry report into the appointment of Barbara Malimali as FICAC Commissioner in its entirety is null and void. The COI report is also unlawful. The COI report's adverse findings are irrational, and that President Ratu, Naiqama, Lalabalavu and Prime Minister Sitiveni Rabuka failed to provide the applicants natural justice. Now, the applicants in this case who challenged the Commission of Inquiry report through a judicial review were former FICAC Commissioner Barbara Malimali, former Attorney General Graham Leung, and lawyers Wylie, Clarke and Laurel, Vaurasi. In his ruling this afternoon, Justice Tuiqereqere has determined that the President, the Prime Minister and the Commission of Inquiry breached principles of natural justice for not giving the applicants the opportunity to respond to the adverse findings against them. The judge says that the work of the Commission of Inquiry after 1st February last year, including the report, is ultra-virus, which means it was unlawful. He found that the extension of the Commission of Inquiry beyond 31st January 2025 was ineffective. As a result, the actions of the Commissioner after that date, including the completion of his report dated 1st May 2025, were unlawful. Justice Tuiqereqere has also found that adverse findings and recommendations against the applicants, including Malimali, former AG Graham Leung and lawyers Wylie, Clarke and Laurel, Vaurasi, were unlawful, including those relating to a meeting at the FICAC office on 5th September 2024. The applicants had argued that the findings were outside the Commission's terms of reference and that they were denied procedural fairness and natural justice. The court also considered claims that some of the Commissioner's findings were irrational and that his conduct during the inquiry gave rise to a reasonable apprehension of bias. The applicants had further challenged the decision by the President on the advice of the Prime Minister to release the Commission of Inquiry report publicly. As a result of the findings, the court has quashed the adverse findings and recommendations and declared the 1st May 2025 Commission of Inquiry report null and void in its entirety. The judge also says the COI chair, David Ashton Lewis, should have provided a draft of the adverse findings against the applicants to them and an opportunity to respond before compiling the report. He says the tirade against lawyer Wylie Clarke in the COI report has no place in the report and adverse findings against him are baseless. While referencing the comments by Justice Ashton Lewis during radio interviews, including his crocodile in the pond statement, Justice Tuiqereqere says it is obvious that the test for obvious bias is satisfied. Stay with us for updates. For Fiji Village News, I'm Vijay Narayan.